as I provide a suggested change to the motto that sits above every family court judge in every family court, from Diu Et Mon Doit, God am I right, to a more apt version for the family court of God help us, we are going to need it, I call for the President of the family courts to step up and to start showing public leadership. Let me explain more, but before I do, let me introduce myself. I am Philip Kedge, the Director of the Mckenzie Friend UK Network and the founder of the national campaign of #LightNotHate, reducing the harm to children by removing lawyers from the family court. I am a retired police chief inspector, and during my last period of service I worked in the Home Office as a project advisor to the Police Minister and what was known back then as ACPO, the Association of Chief Police Officers. In all my blogs, my views and opinions are entirely my own. I honestly believe that Sir Andrew McFarlane, the President of the Family Court Division, is an honourable judge who fully understands the extent and gravity of problems facing the family court. However, he has inherited an institution, an establishment, a division of the High Court of Justice that is perhaps beyond repair and redemption. In my view, it has been so appallingly neglected in leadership by previous presidents that, like a sick animal, it needs putting down to put it and everyone subjected to it out of their misery. After 10 years of working within the family courts and quietly observing how it operates, I believe that the biggest neglectful mistake that the family court has made is to lose sight of the basic principle that with private law cases it provides a service to people like you and me when we have no other place to turn in order to resolve separation issues. For decades, the court has held an arrogant, dismissive and institutionalised view that resolving divorce, child arrangements and financial settlements is something that is to be imposed on us or done to us, that we are not seen as clients or customers, but instead that we are the stupid and ignorant sheep to be herded and directed at their authority, that we are the inconvenience, the problem, the annoyance, the cesspit of human acrimony and emotions that they have to clean up. What is perhaps unforgivable is that for decades the court has relied upon and openly supported the cancer of lawyers infiltrating the family courts who have absolutely no professional duty of care to any child. Where the family court needs to apply a pragmatic, common sense, solutions-based approach to human issues, it has instead allowed these lawyers to turn it into an arena of combat, hate and acrimony, generating conflict for financial gain, whilst children are harmed. The courts have been complicit in the immeasurable harm this has caused to children and parents over the last 20 to 30 years. The court has sat back, happily relying on unscrupulous lawyers for the simple reason that it makes their job easier. By promoting lawyers and signposting people to solicitors, it achieves one important purpose: to remove your voice, to silence the people, to allow easier herding of the sheep. As such, the system has become a self-serving, self-indulgent, self-protecting institution that has lost total focus on the fact that we are the customers. With the self-protectionism and institutionalised inward thinking of the family court, they have turned a blind eye to the carnage and collateral damage that has been met out to families and children who have been torn apart and exploited at the hands of family lawyers. As these lawyers continue to feed people into the family court machine, the court, in order to continue to turn a blind eye, in order to live in denial, in order for judges to sleep at night, institutionally treats its service users with irrelevant contempt, removing all concept of humanity and common sense from its proceedings, before spitting the people out again back into the hands of family solicitors, the vultures feeding off the carcasses of people's broken relationships. And so the perpetual, self-serving, disgraceful and shameful cycle continues. I say enough is enough. No person should stand for this any longer. I do believe that in Sir Andrew McFarlane we have the opportunity to start changes. The recent judicial report called What About Me, the first of its kind in decades, lays bare the problems and issues facing the family court and appears to return to the abandoned principles that family issues are predominantly not legal ones and that lawyers are not needed and indeed harmful. However, in my mind, Sir Andrew McFarlane is about to undermine his efforts, his ideas and his principles. He is about to take the closed and institutionalised path to finding solutions by again turning a blind eye and ignoring us, the service users. The report was entirely aimed at those who are part of the institutions and services around the family courts. The report seems to infer that we, the people, are the burden on the family courts, putting it under pressure. There was nothing in the report that reached out to us directly as the service users. We are still an inconvenience and irrelevance. We are still the sheep. We are viewed as the problem. For the first time in the history of the family courts, we need a president that can now reach out to the public and demonstrate public leadership, to be a champion for change in the eyes of the people. Never before has a High Court judge had the courage to step out from the comfort and safety of their chambers and robing room to talk directly to us. More than ever before, this is now needed, and I invite the President of the Family Court Division to do so. Sir Andrew McFarlane has recently formally endorsed and sanctioned the judiciary report where it states, and I quote, "The system is recognised as broken and in need of radical reform." Well, we, the service user, did not break the system. The system has been broken by the establishment themselves, with the years of self-serving, arrogant and incompetent leadership. A system which has been happy to sit in judgment of others, but has never had the foresight, willingness or openness to consider judging itself. As tens of thousands of children and parents continue to be subjected to this third-rate, third-world, incomprehensible family court system, that has just got exponentially worse as common sense has now left every court building following the recent Court of Appeal judgment in the case of A. Sir Andrew McFarlane now needs to take a public platform to show public leadership and apologise to the people and children who have suffered and continue to suffer at its hands. If he wants to bring about radical change, then he needs to reach out to the public, to talk to us and to engage with us directly. If he won't, then his plans are likely to fail and this opportunity for reform may be lost forever, which would be a tragedy. The start of winning hearts and minds is to start with that apology. We are waiting.